Nagaraj Anaya, not only a realtor, but
what?
Introducing Nagaraj Anaya, Bay Area's top real estate professional. With his in-depth market analysis, targeted marketing strategies, and negotiation skills, he ensures you get the best possible deal. Contact today. Visit nagarajhomes.com or call 858-880-4577. Nagaraj Anaya, selling homes smarter, faster, and for more.
Welcome, Bay Area. This is Nagaraj Annaya, your real estate connection, and you are listening to the Real Estate Show in Bali 92.3. We are on the air every Friday at 6:30 p.m. and Sunday at 12:30 p.m. to bring you the knowledge you need to navigate this complex market. Today, get ready for an in-depth discussion. Sometimes the toughest disputes are not just in a real estate. We all face them in a life, even in a marriage. Disagreements happen. But with some work, we find a solutions. So how do we tackle those tricky real estate disputes? I'm thrilled to welcome Mr. Jeffrey Array, a seasoned mediator and attorney with over 30 years of experience in land use law and real estate transactions. Ready to ask those burning real estate questions? Give us a call at 408 912 5038. Our studio line number is 408 912 5038. Anything on the real estate or anything, you can give us a call and we are happy to take your question. Jeffrey, welcome to the show.
Thank you, Nagaraj. Appreciate it. Very good opportunity.
Yeah, Jeffrey, can you talk about yourself, your experience, so that our listeners, anything on the disputes or anything, they can give us a call today?
Sure. I'm a licensed attorney and have been for longer than I care to think. I'm also a licensed real estate attorney, but mostly what I do is I do mediations and I handle transactional matters with real estate transactions.
Okay, listeners, you're listening to a real estate show. Myself, Nagaraj, and today I'm having a discussion with Jeffrey Array, discussing about the real estate disputes in the transactions. How do we handle any transaction disputes? Because there might be disputes coming for a lot of reasons, right? How do we handle it? So, what is the difference between a mediation and arbitration, Jeffrey?
Well, you'd be surprised the number of lawyers that don't know the difference. So if you don't know it, you're in good company. Almost everybody on the planet has signed an arbitration clause, and all real estate transactions have an arbitration clause. Basically, this is a process by which if you have a dispute, you go to a neutral party who makes the decision for you. That's what the arbitrator does. Now, in the real estate transaction, that can be a very expensive process. It also can take a long time, several months, maybe a couple of years. And it can cost $60,000 to $70,000 to do an arbitration, and ultimately a decision is made by someone else, and it's not appealable. In other words, that's the final decision. So what the alternative here is, or the precursor, is go to mediation. Mediation is much less expensive, and in fact, the California Association of Realtors has a great discount plan to let you settle that dispute. It costs you less than $2,000 for about a 4-hour session, and with the administrative fees. And in 4 hours, you work out the deal, get a settlement, it's over and done with, and it's final, and you move on with your life. So that's a huge difference than the arbitration. But here's the best part. In a mediation, you negotiate the terms with the other side. You may not get everything you want. You may not get all that you ask for, or you feel you deserve, but some compromise works and goes a long way. So mediation is the last best way for you and the other party to negotiate a settlement that you can walk away with.
Yeah, listeners, you're listening to a real estate show. Myself, Nagaraj Annaya. Today I'm talking to Jeffrey he's an expert in the real estate disputes. How do we handle any disputes? Because recently also, Jeffrey, listeners, if you have any questions, you can give us a call. We are live in Bali 92.3. Our studio line numbers are 408 912 5038. Today we are talking about the real estate disputes in the real estate transactions. If you recently have purchased and if you have any disputes or if you have anything else, or like how do we deal with it, right? Like if you have any questions, you can give us a call on 408 912 5038 is the studio line number. Let me go slowly. It's a 408 912 5038. So before even going to a disputes, right? Like this is like your attorney comes in and deals this thing, right? First is like, as in a realtor, we try to do it. Like basically we talk to the sellers and respectively the buyer agent try to settle down that. If both doesn't agree, then that's where you jump in, correct?
Correct. And you contact the California Association of Realtors Mediation Center,
Uh-huh.
and they'll set you up with a mediator. They have
Uh-huh.
a panel. I'm one of the panelists, but you can pick whatever panelist you want. And then you get notified, and then you set a time and a date with the mediator to go to have a mediation.
Okay, because recently there was one transaction was about to close last week. Let me brief you how it was. Like in that, seller was about to sign the last notary, but seller backed out, saying that I don't want to sign now. Buyer has already signed, and Wednesday is the closing date. And Tuesday, seller says, until I get the resolution of the next purchasing house, I don't want to sign. Okay. In this case, sometimes the sellers doesn't, because seller has signed our RPA purchase agreement, but they don't want to sell at the end. What happens in these cases?
There's two things that happen there in Nagaraj. The first thing is if the buyer has performed and funded, okay, they are allowed, that's one exception to the mediation arbitration clause. That's one exception where if they have to go to court before, let's say, the seller sells the property to someone else, they can lock it up through a court action. But the other thing is if there's a little bit of time and you don't know why the seller refused, you can try to set up a mediation and work out what was the problem. And usually through negotiation, something can be resolved. It's rare that those happen, thank goodness, but they do occur. And again, an arbitration could take 2 or 3 years, but more often than not, it's something the seller didn't feel happened correctly. And so going to mediation lets the parties sit down, cool off a little bit, and try to work out a deal again.
It's basically something like you come and try to analyze the things so that you be a neutral, understand it, and you can give us some solution. First is realtors always jump in, try to sort it out. But if the realtors can't sort it out, you jump in, give them the solution. But when it is in the dispute going on, or maybe like arbitration is going on, if as a seller, they can't sell the property to somebody else also, right? That is against the law.
Well, it's not that they could do it. The problem is that at that point, if that occurs, the buyer should get an attorney and file what's called a lis pendens. It's a notice of pending action. Because if the buyer has fully performed, keep in mind they've made an earnest money deposit, right? They've made a commitment with the funding. In fact, the funding may already be in the escrow. All right.
Okay.
So there's a lot of money at stake. The buyer needs that in those situations where the seller backs out the last second, the buyer needs to go and lock up the property with a court action. The more common situation that comes up is the seller's getting ready. They've sold the house, everything's moved, the furniture is out, and they're trying to move to the next house or the next location.
True.
And the buyer backs out, and the buyer says, oh, I didn't like the color of the rug, or I didn't like the back door. That's a better situation for a mediation because you have a little bit more time there, but it needs to bring the buyer in to finish the job and to finish that task, because the risk there is losing that earnest money deposit. If the buyer backs out without any reason or justification, the seller gets to keep the deposit. But keep in mind, they have to start all over with the sale of the property. So if you can negotiate something that works out better, that's what mediation is all about.
Listeners, you're listening to Real Estate Show. Myself, Nagaraj Anaya, the Bay Area Realtor. I'm talking to Jeffrey on the disputes. How do we handle any disputes? Like you are into a contract, and how do we handle it in the real estate? Like what is the real estate law, and how is like real estate transactions been handled? If you have any questions, right, you can give us a call. Our studio line numbers are 408-912 5038. It's not only about the real estate disputes. If you have any questions on the real estate, like for example, you want to buy or sell, if you have any questions, give us a call. I'm happy to take up your questions. Our studio line number is 408-912-5038. And meanwhile, I have a listing, I have an open house this Saturday and Sunday at 1 p.m. to 4 p.m. 38308 Redwood Terrace, and it's a wonderful townhouse, 2 bath, two and a half, 2 bed, 2.5 bath, 1,400 square footage. If somebody is interested to buy a house in Fremont, do reach out, or you can meet at the 38308 Redwood Terrace. I'm happy to take it. So going back, taking a one step back on this dispute stuff, right? Like as you said, buyer might have signed, because in the Bay Area real estate, whatever we do, most of the transactions, especially we are doing, is zero contingencies,
All
right?
right.
Zero contingencies means no contingency for loan, no contingency for appraisal, no contingency for inspection. Contingency means buyer waives of their right, means basically they should have done before putting an offer, right? But you've gone with a zero contingencies after 10 days or a 15 days into a transaction. Buyer becomes like, basically he thinks like this property is not fit for me, some lot of reasons maybe, right? What does the buyer as in, like how can he get out of this, like this transaction? Are there a way without losing a deposit or a EMD?
Well, I think, can I go back one step and suggest that the buyer needs to understand that the law still is buyer beware, okay?
True.
Civil Code Section 2079.5 says that the buyer is responsible for checking out everything about the property before they sign the contract. Also, the buyer's agent is responsible for explaining all of this to them. And for example, a lot of buyers' agents do not understand that they are responsible for checking things like building permits and zoning restrictions and those things. They are responsible to their client to help them through. That's their fiduciary duty. So the buyer needs to be paying attention to what they're seeing. They need to be alert as to clues that there might be an easement. They may need to see that there is something that if they're doing a walkthrough, they need to look and ask a lot of questions. But if you submit a no contingency contract, that means you're accepting it as is, and that's it. And there's really no way out of it from that point, other than you forfeit your deposit. That's what the deposit is all about. It's called the liquidated damages clause. So that's what we have here. So I would say step back and make sure that the buyer does everything they can with their agent to make a close look at the property. Don't skip over DocuSign is very fast. It's very convenient, but I've seen it where people skip over all the disclosure things and they don't pay attention to them. And this is where the real estate agent representing the buyer needs to explain to their client, slow down, take a look at this so you know what you're getting into.
I think that's well you said. A lot of buyers try to squeeze in to some discounted price brokers and everything, but they miss out. Any one small mistake they make, it is basically they will be in the trouble in the future. So that is why the realtor who works with whom they work is really matters, especially in a buying or a selling, because one mistake it can haunt back. So listeners, if you have any questions on the real estate transactions, or if you have like basically gone through some disputes and you would like to share, and you recently bought a property but you're unhappy on some certain things, right? You can give us a call. Our studio line number or 408-912-5038, because Bay Area, it's not easy to buy, Jeffrey. Recently, last week, I put in an offer. House was listed for a 2.3 million. The comparables was for what, 2.35? That's the max I had a comparable. Somebody came in and jumped in and gave it for 500K more. 500K. That's a 2,000 square footage, 500K more. Okay.
It's happening a lot here, and it's all cash.
Yeah.
Which is very difficult to beat that if you're trying to get financing.
Yeah.
And you can't blame the sellers for saying, hey, I want to take the all cash, zero contingency, offer because to them it's a better deal. I think the most important thing here, the takeaway that you're going to have if you're hearing this is, look, make sure you know what you're buying, make sure you've paid attention, read the documents, do your research. Don't assume that everything the seller hands you has been done correctly. Double check. All right, that's what we have to do. But at the end of the day, people buy a property because they fall in love with it, and they fall in love with it. And the little cracks and the other things, we're in earthquake country. Little things can be fixed. Okay.
Yeah.
So go with the thing that you want to do. But if you do have a problem, make sure you get your answers before you sign on the dotted line.
Yeah. So zero contingencies means you should be aware as the agent will be explaining you what you're taking into it. As a buyer, you need to be deciding. And there's nothing called a perfect world, Jeffrey. I think even the real estate is also the same thing. Everything can be fixed, but for how much extent, correct? Is it like how much damage for the buyer? That's what they need to figure out. This throws me to one question. Recently, one of my clients bought a house in San Jose. Okay, and they closed in December. And after they move in, after 4 months, they get a notice from the San Jose city saying that the tree was cut 3 years back, I think 2021 back, 2021, 3 years back, and it was not informed to the city. And now you need to be paying a penalty of $2,500. It's a $2,500, and they need to be paying for, and they need to plant the 2 trees back. Okay, so the penalty is for 3,000 because they need to get the trees also, which cost them 250. So mistake with the seller was they didn't disclose it. Seller was sure about what they did, and they had already seen the notice also, but they didn't inform to the buyer. Now, whose mistake is this one? But listeners, if you're listening and if you're one of these things which catches for your attention, do give us a call. Our studio line numbers are 408-912-5038. The reason I give out the number every time is like if somebody is like connects the story, and if they want to like basically have any questions pops out, right? They can, so that they can get benefited when they ask, because we have the experts here, so they can get benefited. Oh, coming back to this story, Jeffrey, is so what does the buyer as like new homeowner as it, right? It is not the mistake of the buyer agent also here, because he might not, because city has not put a lien against this property now.
All right. And let's take it one step further. Let's say it was sold out of a trust. And so there's nobody alive that even was around when those trees were cut. Generally, that's when you work with the city. It's kind of the city's fault to wait that long before they took action. So part of it there. But the end of the day, the trees have to be replanted. And so, the current owner can negotiate where those trees go and what kind of replacement they need to do. And they always have the option to take legal action against the previous seller to recover whatever losses that they've incurred. So that's the remedy that the buyer would have in that situation.
But in this lawsuit also, right? Lawsuit is better in this case, or a mediation is better in this case? Because
well, mediation is always better, but here's the trick that most people don't realize. Today, and in both the state courts and the federal courts, if you get a lawsuit is filed, the first thing the court does is they send you to what's called alternative dispute resolution, ADR. And so you right away, the first thing you're going to do about 4 months in is you're going to go to a mediation, or you're going to go to arbitration anyway. So all the courts do that, and it's about 90% successful in resolving the matter. Only a very small percentage of cases actually go to trial. So whether you go to mediation through the mediation center at Carr, or you wait till a lawsuit's filed, then you're going to go to mediation. So that's usually what happens. And then there's one third step, and that is if you've been in a lawsuit for 2 or 3 years, and it's now the week before trial, the state law requires the parties to sit down with a settlement judge, which I also do. And the settlement judge sits down with the parties the week before trial and says, okay, what will it take to resolve or settle this case, rather than taking up the time and going before a jury or the court. So you have 3 basic times in there to go mediate and to try to work out something. So you look at that and you say, wouldn't it be less expensive to do it at the very beginning rather than wait 2 or 3 years and then
It
go to
does.
mediation?
I think it does. For 3,000, do you want to go through all that? So it's again comes down to new owner. Like, for the 3,000, you want to go all the way, right?
Right.
Maybe it's a better to talk. As a realtor, what we can do is we can talk to the seller agent, try to help them out if the seller agent is cooperative and he passes on the information to the seller, right? And if seller also agrees that mistake, then maybe pass on that 50%, try to negotiate on that. For this small thing, go to the lawsuit, spend thousands of dollars. Depends on the owner, right? That's at the end of the day.
And you don't recover your attorney's fees in these processes. So that's another thing people mistakenly think, oh, I'll get my attorney's fees. No, generally, most times when you settle, both sides pay their own fees. That's part of the settlement, and that's very standard. So I mean, I've had cases that are dragged on for a long time over a $12,000 security deposit. All right.
Okay.
And at the other end, I've had cases that have gone where the parties have argued and lost $18 million in litigation till they come to me for a settlement. So, which end of that spectrum do you want to be on? I think going in early, again, try to prevent the dispute by doing your homework, doing your research, asking good questions, and prevent the dispute from starting. But if you do find yourself in one, definitely consider mediation. A lot of real estate agents are unaware that that CAR program is available at a very reasonable cost.
Listeners, like if you're working with any of the realtors, right? Like a lot of realtors should be having their mediation available. Okay, talk to them if you have any disputes or anything, right? Try to get that mediation so that all issues can be resolved. As I told you in the early of the show itself, anything can be sorted out, but it is like car mediation center is like it's available, and you should talk to them and basically sort it out. So if you have any, I think we have just 3 minutes left, but still if you have any questions, you can give us a call. Myself, Nagarajan Naya, the realtor. I'm talking to Jeffrey on the disputes and mediations today. And I have a listing coming up tomorrow. I have an open house tomorrow at 1 p.m. to 4 p.m. Saturday and Sunday at 38308 Redwood Terrace. Is a beautiful townhouse. It's for 1,400 square footage, listed for 1.055 million. If somebody wants to get a starter room, do come and meet me at the open house at 38308 Redwood Terrace. So Jeffrey, like basically, I think we have 2 minutes left, but quickly coming back to that zero contingency clause, right? But still, if there is some issues, the seller and buyer can sort it out basically to get the deposit. If something like the seller has not disclosed, buyer can go back and say that you have not disclosed. Maybe it's fair to give the deposit back.
Sometimes the seller is unaware of the problem. There are times when the seller is, a trust, for example. Your parents have passed away and you're living on the East Coast, and you come out and you now are selling your mom and dad's property, and you're not aware of the latest situation with the plumbing or the electrical. These are things sometimes the seller is totally innocent. Again, that is why the law says to the buyer, you are the one buying this, take a look and make sure you do the inspections. Most sellers, if they're convinced that the buyer is sincere and the buyer is willing to do what they need to do, will let the buyer come in and do early inspections and check things out so that they can go into contract with the confidence of a quick close and everyone's happy. So that's my recommendation is sellers be flexible, buyers be diligent.
And basically work with the realtor who has a knowledge so that they can guide you in the right way. Because if they have gone through all these issues, it will be no issues where when you're purchasing or selling the property. Jeffrey, thank you so much for today's discussion. And if somebody wants to reach out, all these recordings will be uploaded on YouTube, and you can go and watch all these recordings on the YouTube and subscribe to Nagaraj Annaya's channel for all the insightful about the real estate. Thank you so much, Jeffrey. If somebody wants to reach out, I'll give out their email ID because already in the video, you can, all the listeners, you can get the email ID from the YouTube video. And don't forget about tomorrow open house. 1 p.m. to 4 p.m. at 38308 Redwood Terrace, beautiful townhouse. And if you want to reach out to me, it's easy. Go to nagrajhomes.com, click on WhatsApp icon, and you can easily connect to me on anything on the real estate. Thank you so much, Jeffrey, for today's show.
Take it, Nagaraj, and my email's on the tube there.
Yeah, thank you, and have a wonderful day, listeners. Thank you.